All right, well, now we're going to look at the case Glossip versus Gross. This is a case that was just decided uh, Monday, June 29th. And what I'd like to do is kind of go through the summary with you to kind of show you some of the key things to look at. First of all, this is taken from the website oyez.org, and that's oyez.org. And you can look up any case that the Supreme Court has decided throughout its tenure. A couple things here. So first of all, we see here's the case. Here's the term that it was decided on. Now I know it was decided over here on 2015, but generally the term itself, the Supreme Court term starts in October and ends in June. So they tend to go 2014, 2015 is what you kind of look at here. Location, that's not that important here, but as we go down the court basics, you can see here, for example, the petitioner, that is the people who are suing. Generally, they take the name of one of the main petitioners, although often it can be, organizations, things like that. The respondent is the person who's being sued, which, as you can see, it's a bunch of where is it? Oklahoma officials, state officials. Um, you can see where it was decided, when it was granted. So this is when the court actually agrees to hear the writ of certiorari, where they agree to hear it. Here's where it was argued. So notice you get it 3 or 4 months of prep time, but more than likely it's worked its way up through the courts. And you can see the U.S. Court of Appeals for the 10th Circuit affirmed the case earlier, so it has to work its way up. However, some cases are kind of fast tracked. As you can see, April 29, 2014 is when this actually occurred. Um, so, this was a fast tracked one. Anyway, couple things. What else do I want to look at? The question is always really the most important thing to look at. Of course, the decision later. But you see, the question is, does Oklahoma's use of midazolam as an initial drug in the execution protocol, the same initial drug used in Clayton Lockett's execution, violate the Eighth Amendment prohibition against cruel and unusual punishment? So that's the question that the court is looking at. Okay. So if you look at the facts, I'm not going to go too much into the facts other than the fact that Clayton Lockett, they attempted to put him to death. The procedure went poorly. He did not die until about 40 minutes later. They think that he went through, he awoke. So a bunch of other death row inmates then sued. They sued that this protocol violated the Eighth Amendment's prohibition against cruel and unusual. First, the federal district court denied the injunction. Okay, so they said, no, you don't have any standing. The U.S. Court of Appeals affirmed it. So that means they agreed with it. So then they appealed to the Supreme Court. Initially, the Supreme Court denied the grant petition for the writ of certiorari, and he was executed. However, Richard Glossip petitioned again, and so they decided to hear it. So here's what we find out. First of all, the decision was 5 votes for Gross, 4 against, so 5 votes against the inmates. And what they decided was this. They said the court held that there was insufficient evidence that the use of midazolam as an initial drug in the execution protocol entailed a substantial risk of severe pain compared to known and available alternatives. Thus, it's not in violation of the Eighth Amendment. Why? Because capital punishment has been held to be constitutional, and some risk of pain is inherent in an execution. Okay. So as we look through, we can see that there's a concurring opinion, And Justice Antonin Scalia, he agreed with it, but he kind of takes a different view. And then Justice Breyer wrote a dissent where he argued that the constitutionality of a punishment must be evaluated based upon concurrent prevailing social and legal standards, meaning the death penalty is no longer constitutional. He's basically saying that that is cruel and unusual punishment. If we continue down through, you can see his arguments. You have other uh, justices who join in the dissent, but what's kind of cool is, and you can kind of see here who agrees with it and who doesn't. Generally, what we see here is it falls right down by ideology, where the 5 members on your left were appointed by conservative presidents, and the 4 appointees on the right were joined or were who disagreed were um, first appointed by Democratic or liberal presidents. So this is kind of the way that you will break down some cases. I have to say that oye.org is probably the best. However, Wikipedia does a very, very good job of it. Wikipedia has taken a lot of criticism over the years for being not very good, but it is a good place to always start. It doesn't mean it has to be your source, but it can be a place where you can at least begin the process of understanding it. So hopefully that helps.